Hello, and thank you for joining us for the next session of the Destination IP Virtual Summit. In this session, Leah Westman and Joseph Wang will present top design practice tips for utility-minded practitioners. A link to the recording and slides will be emailed to all registrants. And please feel free to enter any questions during the presentation, and there's also the chat option. Please also feel free to follow us on LinkedIn to see news about more upcoming webinars. And our speakers today will be Leah Westman and Joseph Wang. And with that, I'll turn things over to Joe and Leah.
Well, hi, everyone. Thank you for joining us today in our pandemic edition conference. I hope everyone's safe and healthy at home. Today, we're going to be chatting with you a little bit about design patents. So Joe is our what we would call our firm expert, and I've gotten the opportunity to work with him over the last year or so on some more design patent work. As many of you probably are, I'm chiefly a utility practitioner. And so there are definitely some things that I've learned during the course of this about design work that are very different than our utility mindset. So that's what we'd like to dive into today to hopefully give you some practical tips and tools to use if and when you do work on design patents with your clients. So just, to back up from a high level, just start a little bit with, what a design patent is. So a design patent, in some respects, is similar to international design registrations in that a design patent protects the appearance of an article, right? It does not cover the function of it, does not cover the parts of it. It is purely aesthetic as to what the design looks like. And, throughout our talk today, we will show you a couple examples of some designs that you will recognize. And so it's just a very different approach to intellectual property, but it also has value in a different sense than utility patents. Design patents, because they are so aesthetically driven, rely really heavily on detailed drawings that convey the appearance of an article. And this is usually instead of an extended specification or written description. The written description, if you will, for design patent is very visual. And so we'll talk additionally about what that looks like and how many views and figures you may need to enable a design patent. And something to keep in mind is US design patents in particular are a bit stricter and have different requirements for patentability compared to a lot of international design approaches. And that's something we'll also dig into today. Next slide, please. So a couple of the things I'd hinted at that we will touch on today, and we'll dig into each of these, are common hazards and common mistakes that some of us utility practitioners will do if we don't have as much knowledge in the design area. Are first, overly simplified drawings. Second, very diverse and extensive embodiments. We'll also sometimes run into insufficient views in the drawings or written description that's insufficient. And sometimes we'll run into improper descriptive language. Next slide, please. So I'll let Joe take it away with the first one of these items.
Great, thank you, Leah. That was an awesome intro and overview. So like Leah was saying, we're seeing these issues that a lot of folks who are practicing in designs but still are importing improperly concepts from utility practice. They tend to get in all sorts of trouble, oftentimes with 112 rejections. And unfortunately, a lot of times these errors are actually fatally defective in terms of dooming a design application, potentially to the point where it cannot ultimately get any rights at all. So, in hopes of helping you folks out there, avoid these things at the outset, we want to bring these sort of common mistakes to your attention. The first one here is that a lot of applications are filed with overly simplified drawings, and and this just comes from a very natural inclination from utility-minded folks trying to be broad. There's a lot of reasons for this, but trying to sort of just cut to the chase and really dig down and try to look at the heart of why people are doing this. It seems that a lot of folks have this, I guess it's a habit for us, on the utility side. I practice a lot of utility work too. We are used to utility claims being open-ended, and because they're open-ended, a short list of details is going to be broader than a long list of details, right? This is so common and ubiquitous in utility practice, it just goes without saying most of the time. But looking at why this is the case, it's not just some cultural habit that utility patents practitioners have done. There's a legal reason for it. Here in the U.S., the utility claims are open-ended because of the transition word in the preamble of a utility claim, right? We have the word comprising in our claims. That's what makes them open-ended, in contrast with the word consisting, right? This sounds really basic, fundamental, almost like law school level stuff, but going back to this rationale for assuming that fewer details equals broader claim, this is where it comes from, right? We need to recognize where our habits and our practices come from, so that we know when those habits and like assumptions don't apply. And design practice is a case where they don't apply, right? A typical design claim is a formal claim. The drafter has very little latitude in what they say. And the formal claim usually takes the form of something like the ornamental design for blah, 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 as shown. As shown. And if there are some statements that further describe the design for the article, we add the phrase and described right after as shown. But there's very little wiggle room in what a drafter can write. They can pick the title of the article, which is the title of the application. They can decide whether additional description is going to be present or not, so that dictates whether the design claim has the phrase as described or not. Right. But notably missing here is the word comprising, right? And so we really have to make sure that when we start practicing designs, that you prepare to work with a design claim, either your own drafted one or you're prosecuting someone else's design claim that transferred into your firm. You have to drop the assumption that fewer details equals a broader claim. That's not the case. I believe we go into some of this more in the next slide, right? Michelle, next slide, please. Yes. Okay. So the consequence of that is in designs, as Leah mentioned, the disclosure and the claim are visually specified using the drawings, right? So the consequence of this, the fact that we're not using the word comprising, is that a simple design is not necessarily a broad design. And conversely, a complex design is not necessarily a narrow design, right? What determines the breadth, the claim scope of a design claim? The Federal Circuit set it out very explicitly in 2008 in the Egyptian Goddess versus Swissa case. Right? It depends on the prior art, right? So the applicant can decide what the design is, but the applicant does not choose the scope. This is totally different from utility practice, right? It's according to the Federal Circuit in Egyptian Goddess, the ordinary observer test was reiterated and restated as the sole test for infringement, for obviousness, and for anticipation, with a twist. Egyptian Goddess said that the ordinary observer is assumed to know the prior art. The ordinary observer is assumed to understand how much art there is, how close the art is, and so if there's a lot of art and it's very visually similar, the ordinary observer is assumed to know what the little details and differences are. The minor differences will be important to that ordinary observer, and whereas if there's very little art, then minor details shouldn't be that significant to the ordinary observer, right? And so when you are making design drawings, if you choose to omit detail for whatever reason, you are not making a broader design. You are making a different design. And by that same token, if a competitor starts adding detail, right, they are also making a different design, whether it's an attempt to design around or to even copy your client's product. Right. We have situations where the product is very detailed, but unfortunately, the design practitioner trying to protect that design omitted lots of details. So, boom, now the client has a design patent, but it doesn't even cover their product because their product is so much more detailed than the claimed design. And therefore, if a competitor were to copy the highly detailed product, it's very questionable whether that design protection really would apply or not. And this can be seen fairly intuitive, right? In art, empty spaces, are part of the design, right? It's like the clean elegance of something simple looks different to a consumer, than something that's very richly, ornately detailed, right? And so that sort of fits the ordinary observer test quite well.
I think there's a good example of this. Michelle, if we could go to the next slide, kind of just a visual example. And this is an example of what Joe was talking about from the Egyptian goddess, is that, the scope of the design, it depends on the prior art and under the ordinary observer test. And the applicant here, for instance, chose where to place the bullseye itself, but prior art means that the number of rings was already determined in this design. Joe, do you want to elaborate on this example?
No, I think that's that was perfect. That's a good illustration of the Egyptian goddess rule. Yeah. Want to take the next slide?
Sure. So we kind of covered a little bit of this already, but adding or changing or removing details, it doesn't change the scope of the claim. It changes the design concept itself. So imagine, for instance, a lot of times a lipstick tube will have a very distinct shape and different number of lines. And a lot of you women, or if you have wives that like a certain type of lipstick, you probably would recognize a tube that has 2 lines in a certain place and is a certain color as the brand that you like, as opposed to something that has 3 or 4 lines on it. So it just changes this concept because it's very aesthetic. Again, it's very aesthetic. So under the ordinary observer test, a competitor, can deviate from a claim design by changing those details.
Ooh, I've got a good hypothetical to back that one up.
Okay.
Just real quick, imagine a sneaker. And before that, actually, we really might someday come up with like a version of this presentation with a lot of like good examples and bad examples. But the trouble is the bad examples are hard to take from actual practice because, as you guys may know, designs are never published before grant, and so a lot of the ones, especially the fatally defective ones, don't become known to the public. But anyways, imagine this hypothetical in your heads, everyone. That suppose you got a sneaker. Right, it's like you make a sneaker, and suppose you got a valid, assumed valid design patent for a sneaker decorated with 1 stripe, right? And then you got this patent, it's granted, you got these rights, so you go and you sue Adidas because their 3-stripe sneaker could be arguably infringing your 1-stripe design patent 3 times per shoe. Right, so it's not a frivolous suit. It's but they would have a very easy defense by saying an ordinary observer giving the attention that a purchaser usually gives would not confuse a single stripe shoe for a 3-stripe shoe, right? And so the ordinary observer test is for infringement, anticipation, and obviousness is what we should be looking at to determine how this is going to play out, and this is sort of reiterates the fact that the simpler design does not broadly encompass a more complex design. It's just a different design.
I like the Adidas example. I think all of us recognize Adidas shoes with 3 stripes, and adding or taking away one makes it a different design that imparts an idea of a different brand almost, which veers into trademark territory. We won't go there today, but
we'll get
Michelle,
very close.
very close. Michelle, if you could, oh, there we go. So the ordinary observer test we've been talking about, and Joe pulled out a few quotes that you might want to walk through that define the ordinary observer test itself.
So this is the full test, and I think it's actually worth committing to, at least a 3x5 card or memory for any design practitioner, right? This is the full ordinary observer test in its entirety. Right? If in the eye of an ordinary observer, giving such attention as a purchaser usually gives, 2 designs are substantially the same if the resemblance is such as to deceive such an observer, inducing him to purchase one supposing it to be the other. The first one patented is infringed by the other. So you see why I was snickering just a second ago with Leah about the trademarkiness of design patents. The public policy and the law itself for U.S. design law is very trademark sounding, right? It's talking about a purchaser and getting confused about which one to buy. I mean, that is straight up confusion in the marketplace concepts that we typically would see on the trademark side of things. And this is the test for whether a design is infringed by another design or not, right? This is not an element by element analysis that we do on the utility side. If we're not applying the ordinary observer test in examining 2 designs against each other, we're not doing it right. And so this is why I say this is so darn important that design practitioners really get familiar. Like this should be like the first thing in their minds when they start looking at design comparisons, coupled with that business from Egyptian goddess, where the prior art is assumed to be in the head of the ordinary observer, right? That was a new twist that happened in 2008, but that is the design law.
Michelle, if we can go to the next slide. One of the things that I found striking as transitioning to learning some of this design practice is that, as Joe kind of just mentioned, is that if you have, for instance, a 103 issue and you're looking at the obviousness of the design, in a mechanical utility case, you're looking for that element or that limitation that's not present in the prior art to try to distinguish. And that's not the case here, right? You are, as we just talked about, looking as an ordinary observer at the design as a whole. And it's just not an element by element comparison, which is something that's it's just very different approach. So I think, Joe, do you have anything else to add on this point? Otherwise, we'll move on to overly diverse embodiments.
Nothing planned, but we just got a question from Daniel Johnson. I think maybe this is a good time to address it since we're about to switch to the next slide. Daniel Johnson says, picking up on the sneaker example, would it make sense to file 2 design patent applications, one for the 1-stripe case and another for the 3-stripe case? More generally, should one file multiple applications to capture related designs? Great question, Daniel. Just to give you a short answer here, but this is actually a topic we pick up later in this deck, so stay tuned for all that. But as a bit of an appetizer, to not leave you hungry for all that time, it might make sense to file on designs that your client doesn't intend to implement, but their competitor might implement. There is some danger of cluttering up the art, because if here the applicant is spewing forth all these different designs that they themselves are proactively stating as non-obvious variants of each other, you could potentially poison your own well if you overdo something like that one. But it's definitely something to consider. And with that, I'll leave it to the later discussion. Thank you, Daniel.
Yes, thank you for the question. And moving on to the next point of discussion here is overly diverse embodiments, which this ties
Daniel
into
was
what
psychic.
we're talking about.
This is our next topic. Great segue.
So
you want to run with this one a bit?
Sure. I generally, in utility practitioners, we like to cover as much as we can, right? That's why we try to get broad claims. We try to get a lot of variance on them as possible. You can see down here, this design is for what we all know as a crock on the bottom of the slide. And, you know, on first glance, the three figures there all look pretty similar. We all, you know, most of us who have seen a crock in our life go, oh, that's a crock. But when you look closely, actually, there are variations in the three figures down there. And this type of filing where all three of these figures, if all three of these figures were in the same application, you'd run into a multi-way restriction. And, you know, design patents are not published until they're issued, and restricted designs, you know, they have to be pursued in divisionals. Otherwise, they are dedicated to the public, meaning that if you filed one application with all three of these designs and you got a restriction and you chose not to pursue a divisional on, let's say, the third design with the handle all the way on the left, then you're giving that up, right? And you don't have the ability to come back and file on that later because it's dedicated to the public. So clearly this can cause some issues for the client, especially when they're thinking that they may, you know, act on more than one of these designs. And it's like Joe had just mentioned, there is a potential for you to make the art space very crowded with this type of design. What I find interesting with this example that we provided is you really do kind of have to look closely, and the difference, kind of like spot the difference here. And on the first design on the left, the difference is having that, you know, point in the middle of the strap at the top of the shoe, whereas all the way on the right, you have a fully pulled up strap. So Joe, do you have other thoughts to add here?
I think you covered a lot of the main points very well, Leah. I could fill in some more on the dedication to the public. That may be a little bit new and confusing. Obviously, on the utility side, if you you know, it's a little bit you know, it all comes from FESTO really on whether this prosecution history estoppel attached to how you responded to a restriction requirement, right? And so the big case on point is from the Federal Circuit is you know, Malibu Boats, yeah, a couple of years ago, and you know, basically in that case, you know, there was a you know, several embodiments filed originally. The application got a restriction requirement. One elected embodiment was pursued all the way to grant, but the others were not. And then in litigation, the patentee tried to assert, you know, sort of a broad interpretation of the embodiment that got granted, and the Federal Circuit just slammed that down and, on FESTO grounds, saying that, you know, prosecution history estoppel will apply here. That, you know, since the examiner parsed out the original subject matter into separate designs, and the applicant, you know, sort of accommodated that, right? He sort of implicitly agreed with that. They don't get to recapture that subject matter, right? So, you know, you cannot recapture your canceled embodiments in the design patent granted for the elected embodiment. You know, that's why they become dedicated to the public unless they are separately pursued in their own divisionals. Bernie Greenspan in the Q&A box says, do divisional applications in design patents show fewer drawings? Yes, if not immediately when you respond via restriction to your restriction requirement, the examiner will require it. The examiner will require cancellation of all the non-elected embodiments, including their drawings, including their portions of the spec. So yeah, that is going to happen. If you're very nice to your design examiner, your response to a restriction requirement actually is fairly extensive. It will send in replacement drawings that cancel the non-elected drawings. It will also have a bunch of spec amendments, you know, to get rid of the descriptions of the canceled drawings. And if you have supplemental descriptions that no longer apply, it would be, you know, very good to do that there. If you don't do that there, you know, the examiner is going to make you do it sooner anyway, so you really can't get away from it.
Looks like a follow-up question for you, Joe.
Well, and the chat has one too. Okay, so first up was Alexander Belinsky asking, could you please repeat the case related to dedication of public? The name of the case, I keep on calling it Malibu Boats. Malibu boats. If you Google Malibu boats and design patent, you can't miss it. It is huge. Thank you, Alexander. And then Bernie follows up. So we do not show the public the dedicated drawings except in the file history. They do appear in the file history. Yeah, when the elected embodiment grants as a design patent, then its entire file history becomes available to the public, right? So that is true. Cool. Well, cool. Glad we got some some questions on that point.
Good discussion there.
When I first saw the implications of that, when my jaw dropped a bit too, I said, "Oh my goodness, this is going to be crazy," because look at so the overly diverse embodiments would is like when a ton of material gets packed into an original application, right, and it gets restricted later. I see examples out there, and we should not assume that a lot of that every granted patent is a good example of what to do, right? Because and design examiners have altered their practices, and they've sort of gotten more consistent over the last few years too. So it's not necessarily good practice to follow something that a major corporation did in something that granted a decade ago or even 5 years ago. Right. If you see a design application, a grant out there, you won't see an application. You see a published design grant out there with, 256 embodiments, and just pages and pages of drawings. That was a big risk because whoever filed it that way was vulnerable to a 256-way restriction, and you'd be hoping that the client is on board with paying for separate divisionals on all 255 of them. So that's or dedicating those non-elected ones to the public, right? So cost concerns for a client, that's why that shows up here on this side. And like Leah mentioned earlier, it works even if you had this unlimited budget. So fine, you get your design application, you get your 255 divisionals. Now there's 256 designs out there that the applicant has agreed are all different and non-obvious over each other. Under Egyptian goddess, you have cluttered up your own art, right? Now it's very difficult to argue for a broad interpretation of any one of those designs, especially if they all look very visually similar.
Yeah, I think we'll wrap up overly diverse embodiments. I think there's one more slide here.
Is there?
Which we've touched on this already, I think. But
yes. Oh, and I see Alexander found the citation from Malibu Boats in the webinar chat. Yeah, folks, I just want to point you to that one. Thank you very much, Alexander. Right.
Okay.
Oh, just one last thing. The reason this slide is here is just to make sure that you understand that the folks get that it's still assessed at the purchaser level, right? So if the purchasers wouldn't confuse the designs, they're in the knowledge of the prior art. That's what's supposed to separate how designs are distinct from each other. And just to connect to Daniel's question earlier, I don't want to pick on the language Daniel used, but because it's very common for people to use this language, I just want to call it out. The last half of Daniel's question said, should one file multiple applications to capture related designs? And when I see people talking about related designs, it's a bit of a concern because it's in utility cases, features can be related, functionality, behavior can be related. On the design side, and this is the purpose of this slide right here. It's like the two designs are either different or they're not different, right? The dividing line between different designs and same design is the ordinary observer test. So it's actually fairly dangerous to state that designs are related to each other if they're not the same design, and it may have IDS implications in your prosecution, but that may be beyond the scope of the top tips that we're presenting here.
Okay.
Thanks,
well,
guys.
I think with that in mind, we'll move on to number 3, which is commonly there are insufficient views in design patents that cause some problems. So this one's kind of fun. Java, I'll let you start this one.
Okie dokie.
If you'd like.
Insufficient views is sort of like a cousin to the oversimplified drawings problem, right? You know, making drawings is not exactly in the central wheelhouse of many design practitioners. You know, we often like to use external illustrators who have far better software tools and artistic skills than we have. But they charge, and there's a cost implication for the practitioner as well as for the client, and so there's often a temptation just to file some drawings, just the minimum drawings necessary to get some protection going. Oftentimes, since designs don't use provisionals, a lot of first file designs are sort of minimalistically filed, and of course that just overlaps right there with the temptation to think that fewer details gives you a broader claim anyway. So out there in practice, there's it's not uncommon to see not just details omitted, but entire views omitted, right? And the MPEP and the examiners aren't exactly a big help either. No offense to the examiners, they're doing the best with what they're doing, but they just sort of look at is the subject matter clear from the drawings, and what's the bright line for is it clear or not, right? They can't give us practitioners that much guidance. It's going to depend on the article. Right, a simple object like a basketball, you can probably get away with a lot fewer views than something very complicated with a lot of nooks, crannies, hidden recesses, and things like that. Right. This slide here is the key to solving that problem. Right. The standard for getting past 112 is that nothing is left to conjecture. All right. I mean, and this means you can't rely on mental visualization or assumptions or defaults or verbiage from, we'll talk about that too, about just adding verbiage to the spec to paint a picture. It's like it either is visibly present in the drawings or it's not. Okay, and so just, yeah, go ahead, Leah.
The interesting thing I found with this as a utility-minded practitioner is that there's a lot that I will fill in with my mind about how something looks. And I'll look at the set of drawings and go, oh, well, of course, on the other side, it looks like this, and on the bottom, it looks like this. And then, when I come back, I'll go, oh, we didn't actually show that. I just figured in my mind of how it would look. So it's something to be very cognizant of because we're so used to describing things with words, and that we have to remember that that's not the case here, right? That can't fill in and explain what you're visualizing or thinking of.
Absolutely. Absolutely.
We have some general rules of thumb for different types of drawings. Michelle, if you could go to the next slide. So, Joe, go ahead.
Okay. So in order to make sure we cover the article of manufacture, right? So here in the States, we don't do disembodied designs floating in space. We have a design for an article of manufacture. If it's a three-dimensional article of manufacture, I mean, well, all of them are, but if it's a three-dimensional design, you're going to have your 6 orthogonal views at a minimum. I don't want to say like everything beyond the minimum is optional, but you're going to have like the basic front, rear, top, bottom, left side, right side views, right? There's your 6 orthogonal views. They have to be dead on the money orthogonal, and then, I really would not go fewer than 4 perspective views for a three-dimensional object because you want to build in some redundancy in case there's an inconsistency somewhere, and then you're going to want some originally filed subject matter to support an amendment. So, in sort of a more thorough situation, you could do 4 perspective views on all 4 corners surrounding the top of the article, and then do another set of 4 perspective views up at the bottom of the article. And of course, if you do multiple embodiments, we're saying it should have its own complete set of drawings. Don't try to overlap or say that one drawing applies to multiple embodiments. You're going to get a problem with your examiner from that. The 2-dimensional designs are still applied to a 3-dimensional object, like a computer display. And but front view is probably sufficient because if the design only appears on the front view, that might be good. This is typically done in like graphical user interface cases, whether it's a static GUI or a transitional animated GUI. Oh, I see a question
We actually
from
have
Alexander. You want to take that one, Leah?
oh,
It's
use
in
an
the chat.
appendix to an application with photos of. So the question is, could you please comment on the use of an appendix to an application with photos of design, which could be used for an amendment, avoiding a new matter rejection? So we were actually discussing this the other day because I think there are some varying viewpoints. I think at a minimum, you know, what we were just discussing here, you do want to show, at least for a 3D object, 6 orthogonal views, and for a 2D object, at least a front view, and have that already in the figures, right? And preferably whatever you would like to amend with is somewhere in that set of complete figures to begin with. And I think what we discussed the other day is, while an appendix could be used to add other subject matter, it kind of gets into what we were talking about earlier about creating a problem of cluttering up the art and potential issue of prosecution history in this case. Because if you have an appendix with, you know, hundreds of other views or drawings, and the application is eventually issued to a design patent, then that's all open to the public. And if you want to later go after a design that was in the appendix that wasn't in the original set of figures, you may run into a problem. I think that's my preliminary thought there. Joe, do you have anything to add?
Just a little bit to expand on that, which is the central uncertainty that we have with an appendix. I know examiners themselves have been encouraging them. I mean, it does give them make their jobs easier, but I don't think they're really thinking about what it does to the patentee's rights down the road. You know, all this unclaimed subject matter is being filed, you know, on the filing date and never incorporated in the claim. Like suppose you get, you know, suppose you don't need the amendment, right? It's all this is done sort of preemptively or proscriptively, right? Or you use some of the material but not all the material. But either way, there's this, you know, it's undisputable that the applicant had possession of this subject matter on the filing date, and it's undisputable that the applicant did not claim all of it. So now you have to track that, right? It's like, so you've got rights from your granted patent. It's conceded that it doesn't include the stuff that you didn't claim. And you know, like Leah said, the stuff you didn't claim, you know, could be prior art against your future designs, as well as you know, arguably you know, dedicated to the public via estoppel from your claim design. There's just a lot of uncertainty in what the overall effects of an appendix are going to be to interpreting the scope of your actually granted claim. So in my opinion, and it just seems so speculative that it's going to be ultimately helpful. Yeah, you get extra ammunition in case you want to file an amendment, but what's it going to do to your actual IP? How much intellectual property do you get at the end of the day when you do this stuff? I think it's just extremely speculative, and I'd be very hesitant to recommend it until we get some solid case law on the subject.
So we did have another question roll in. I'm actually, Michelle, can we go to the next slide here? So ironically,
another psychic
attendee. Our next example was views of a shoe. And so we thought it might be good visually to look at some examples of what we're talking about when we're talking about 6 orthogonal views in addition to all these other potential drawings for a 3D object. I don't know, Joe, if we want to jump into this first and then address Randall's question, or if you have something to add right away.
Well, I think first, Randolph, it sounds like an interesting question, but I'm not too sure what you mean by pivot point. Perhaps expand on that question and we can answer it in a few minutes. I think,
okay.
yeah, what
I'll do then is I'll jump into this.
Yeah.
So just visually, design patents, I know for me, a lot of this clicked when I actually started seeing applications in front of me that we were working on. And so this is an example of a long ago issued design patent to a spiral heeled shoe. As you can see, you can recognize from here that this is a high heeled shoe where the heel itself has this spiral pattern, this very distinct design. And as we mentioned before, so this is a 3D article, meaning that at a minimum, you want 6 orthogonal views to be able to see each view of the shoe from each angle. So we're seeing figure 1 and figure 3 here from the sides, figure 4 down the shoe from the toe towards the heel, figure 2 in the opposite direction. And then we're also seeing figures 5 and 6 top-down and bottom-up views. Now, there's arguably, you may want to also include some perspective views here because this shape is relatively symmetrical. They didn't include those here, but they did cover every view that you could from an orthogonal perspective. But they also, because there's this one portion of the design, this heel that's very distinctive, have included four different views along the sides of that heel from figure 8 to figure 11, and then top down and bottom down views over here in figures 12 through 14. And so this is kind of just a minimum of covering every view of the design. Now, here's the thing. Many of us have seen a high-heeled shoe before. We could imagine, for instance, what figure 4 would look like, right? We don't necessarily need figure 4 looking from the toe back up to the heel. We don't need that in front of us to visualize what it looks like, right? But nonetheless, to fully enable this design, you have to have that view, right? You have to talk to the draftsman about placing that in there. Something else to notice here about that makes the views a little bit more sufficient is that there is shading along the side of the shoe and the front of the shoe to indicate the curvature of the shoe, which is kind of a whole nother topic. But Joe, do you have anything to add with this here?
I just want to point out that this looks like an older design that today may get an objection from the examiner. Notice that figure 1 and figure 7 are the same view, but of two different embodiments of the shoe. And in the situation, I would expect, definitely greater than 50% odds, maybe even greater than 80% odds that this set of drawings filed today would get a rejection from the, or at least an objection from the examiner if the embodiment of figure 7 didn't have its own complete set of views. So
just because
basically,
of that
don't be afraid to order a full set of drawings.
Can we go, before we go to the next view or the next slide, I think let's talk about Randolph's question here, Joe. So for those of you who can't see it on the screen, the question is, how do you show a pivot point or an axle, for example, in a shoe application? If the handle pivots around the attachment point, should this be shown with multiple views or by using text?
Ooh.
What do you think, Joe?
Okay, so the goal of showing a design is, if we go back to the ordinary observer test, it's so that it's evaluated from a purchaser's point of view, right? And so, what if there are moving parts, right? Is sort of the sort of umbrella version of Randolph's excellent question. If it's being sold, it may or may not be moving. Like we don't necessarily, the Crocs shoe had like a strap that could raise or lower. And we don't necessarily need to show it in every position, right, to specify what the ordinary observer would look like. And so, if this question comes up, in a situation, Randolph, I would definitely think carefully. Why do you want to show, the fact that it can move? Is it necessary to show what an ordinary observer would see when they make a purchase, or is it perhaps some functionality that's creeping into a design case? I think for time reasons we should move on, right?
Yeah, I think we have one more example here.
A touch of everything.
So after all that discussion of how many views you need to show a 3D article, this is sufficient to show a 2D design, right? So this is the GUI on a phone. I believe this was a display screen. It's a design patent for Snap. And this is sufficient because it's showing it in full. So it's very different considerations in 2D versus 3D. So
good point.
I think with that, we'll move on to insufficient written description. So Joe, this is your area of expertise here.
Oh, thank you. Just real briefly, the big takeaway here, everybody, is that enablement and written description are separate. You can enable something by putting all the pieces there, right? Like dumping Legos on the floor. For you kids who play with Legos, right? If all the pieces are there, yeah, okay, you say the design's enabled. However, unless the particular arrangement has been like specced out and clearly specified at filing that it could be claimed as a singular holistic design. Remember, nothing element by element. If it right, it's disclosed, but it's not, doesn't meet written description. The claim doesn't meet written description, even if its constituent parts are all there at filing date. And this slide is taken from directly from the USPTO, because they were having and they still do have problems explaining this to a lot of practitioners. So we just want to reiterate, practitioners love to argue this when they are in the midst of a utility mindset, but they will likely lose, and they have been for a while. This is written description is directed to whether that particular singular appearance could have been seen as something claimable at original filing. Next slide.
We touched on this earlier.
This is Alexander's question.
Yes.
Yep. So
we'll probably just
remind everybody, and then we can go.
Okay, so we touched on earlier, you do have the option in design patent to file an appendix of unclaimed subject matter. Like Joe mentioned, this has been encouraged recently by some examiners and different practitioners who are supporting future amendments. The flip side of that is this will be published with the grant to design, right? So you have to weigh the option of having the support in the written description for the amendment against the IP portfolio as a whole and what you may want to file for later. So that, I think, we'll probably move on to our last item for discussion here.
Yep. Okay, so I think some questions have touched on this before. A lot of utility-minded practitioners want to use words to fill in whatever might be missing from the drawings, or to reserve amendments or something like that. When in general, these attempts fail, and if it's just not okay. The examiners will ask you to remove the language it is very uncertain whether, even if retained, that language would have the desired effect in litigation. It's at best speculative and untested practices, and and certainly not supported by any case law. And at worst, it is just it just looks adds estoppel and looks bad in your prosecution history. You can't use language to just say here are some more embodiments that we didn't file drawings for. You're disclaiming solid line stuff. Solid line stuff is specifically claimed, and to start disclaiming it with words, you sort of have a consistency problem there. Talking about the function of the article, this is something your inventors may actually really wish you would do, because they're proud of the function of the object that they created, or their invention, especially if you're also doing a suite of utility patents and design patents for surrounding a new product release or something like that. Remember, design is ornamentation only. Anything that is non-decorative is irrelevant at best and damaging at worst for functionality challenges. And so anything unrelated to ornamentation, it should be left out of your design application. I think I think you guys can pretty much see where this is going, right? So no using words to make up a picture, like imagine the two-strap backpack with just one strap, either the right strap only or the left strap only, or something like that. That would be a word picture, and the examiners will just reject all that stuff.
Okay, I think we'll wrap up then, and hopefully have a few minutes at the end for some more questions. So all this to say, a lot of us utility practitioners run into a lot of particular pitfalls with design patents. So why would we file them in the first place, right, if it's going to be all this trouble? And at the end of the day, it's a very different tool for your client in their intellectual property portfolio. And because it's covering something that's aesthetic, that's a design, it's slightly different than a trademark, slightly different than a utility patent, but it does fill a space to help protect and add value to your client's business nonetheless. So if you could go to the next slide. The most easy way to convey this is some designs we all recognize, right? So this is an iPhone at the top that is protected by a design patent that Apple owns. And I'm sure there's many iterations of designs that Apple has filed on. But that's part of the reason why a Samsung phone looks different than an Apple phone, right? And it's why we all have this ability when we're, when we're out and about pre-pandemic, talking to people, we know right away if they have an iPhone or an Android based on what they're holding in their hand because of the design. You know, it's the same thing below where you look at toy construction set. That's one of many Lego design patents. They also have one for the little Lego guy. And there's a reason that, so their competitors, for instance, Mega Bloks, have slightly different looks than Legos do. And there's a reason why the pieces of the Lego set, and now fortunately this kind of gets into functionality, but there's a reason why they click together, why they're all the same design. And it's very distinctive. And so it's something that a consumer or any user of the article will know and associate that company or that brand with it. Next slide.
Good point.
And I also had to throw this one in here. This is an OPI nail polish bottle. There are many different designs for nail polish bottles. This one, if you're at the salon, you know that these are the OPI bottles because of the design as a whole that includes all of these various features with that particular, for instance, ratio of the cap to the bottle, the slant of the bottle, all together. That indicates that that is an OPI brand nail polish, and it's probably pretty good quality. So, you know, at the end of the day, I think there are still a number of reasons to file design patents for your client to help with their company value and their brand and the products that they are producing. But there definitely are some things to be aware of as you're doing that. So next slide, Michelle. I think we're just open for more questions if anyone would like to.
In the chat, it looks like Bernie Greenspan has entered a question. Saw a design patent for an ergonomic mop handle. Shouldn't the word ergonomic be rejected? You know, Bernie, that's a good point. I think it doesn't really add anything to the ornamentation. Like it doesn't, you know, the word ergonomic doesn't describe the way it looks. It does sort of bear on what it does or, you know, what it can do. So, you know, on those grounds, it seems like it brings in a certain measure of risk. You know, maybe not a high measure of risk, but you know, it certainly doesn't offer any benefits. The worst case I saw was you had a federal circuit case, Richardson versus Stanley Works. The design patent there was called multifunction tool. It's like talk about loading a functionality challenge, you know, gun and aiming at your own head right off the bat, right? So the word ergonomic doesn't rise to that level of inviting disaster, but I don't see much benefit from including it.
So we've got a couple other questions in here. Alexander's asked, some designs may include a registered trademark, and its invalidity of a trademark, could that affect the validity of the design, which it includes?
Answer is no. The appearance of the product, whether or not it includes a trademark, is the appearance of the product, and the legal validity is irrelevant. Doug Portnow asks, can you talk about European design registrations? Is validity addressed later in court if there's infringement suit? Are there amendments allowed at the time, or the European therefore affected by Brexit? Lee, you want to take that one?
I can speak to the first part of that about European designs. We'd mentioned very early on that international design regimes are quite different than the US. So for instance, in Europe, it's a registration, just like a trademark that or a copyright that you would register. It is not something that's necessarily examined. That depends on the country. So I believe in Europe there is a review of it, but it's they're much less stringent in their response. So at least when I've worked with European design practitioners, their figures, for instance, they don't need to show all the different views. If it's a 3D object, they can do something that looks like a schematic. So at least that's my experience so far. Joe, what do you have to add with regards to EP practice?
Yeah, I'm not sure if we're talking about European countries or the European Union, which offers a European an EU-wide design registration. If we're talking about an EU registration, it is definitely not examined. That's why you can get the registration like within a few weeks. That's it, and you just apply for it. You get it. They have very lax requirements for drawings. No shadings required, which is why a lot of times U.S. designs that claim priority to an EU registration are in serious trouble because they don't meet USPTO standards for drawings. So I don't think EU design registrations really have an amendment process because they, whatever you file, it pretty much gets stamped and registered. And then in terms of Brexit, have it from recent communications with one of our European associates that EU designs will sort of automatically get spawned off into the UK after, at the December 31 mark, and then they'll have separate maintenance fees there, but yeah, they'll be separated. There's a clean way to separate them out through the Brexit transition. We can talk offline about that.
We did have a follow-up question on that, which is internationally, will designs be considered closer to a trademark or a copyright?
It depends on the country. By the way, design practice varies much more widely country to country than utility practice does. So some countries, they don't even offer design patents at all. US is one of the few countries that does. Right? If it's just a registration, it is very, very close to trademark practice. Here in the US, we've got this sort of hybrid between patent and trademark.
And then Jordan was asking if we have any good resources, books, or websites that compare good and bad design examples and practices.
I'm not aware of any.
Something
we said earlier is
like, take a look.
Really bad examples don't get granted. And if they don't get granted, they don't get published. Right? Like fatally defective applications. And those are the ones that a lot led to the experiences Leah and I are talking about here. So we wish we had a compilation, but a lot of it has to do with confidential information that we have to generalize for presenting to you guys here.
So, well, unless anyone has any last minute questions, we just want to thank you all for joining us this Friday afternoon. And thanks to those of you who have been to other sessions in our conference. We wish you and your families stay healthy during all of this, and enjoy your weekend.
Definitely. Thanks for coming, everybody. Hope to see you at the virtual happy hour later.